Hello and welcome to Property Hotline on India's first property channel, Magicbricks Now. I'm Kavita Krishnan. Today we are answering all your legal questions related to property. So if you have a question, feel free to contact us. Contact details flashing on your screens. Our expert for the day is Anshuman Jagtap. Now Anshuman is an associate partner at Hariani Co. He joins me in our Lower Parel studio. Anshuman, welcome to the show. We have Gagan Arora who's dialed in from Assam. Gagan, how can we help you?
Kavita, am I getting your name correct?
Yes, Gagan. Go on. Tell us what's your question.
I have booked a house which is about 24 square feet in the H Stars Ramprastha Builder Sector 37D, Gurgaon,
Okay.
which I had done in 2008. Now the delivery of the project was scheduled to be done in 2011 and 12. However, the delivery has not happened so far, and according to any guesses, I think it will take another year and a half more for the delivery to take place. So my question is in actually three parts.
Yes.
Hello.
Yeah. Go on, Gagan.
Firstly, can I take any legal course against the builder? That's number one. And secondly, there is a High Court judgment of Delhi which says that there is no payment required on the service tax on the properties which were to be constructed before 2012. But my builder has charged me the service tax. That's the second question.
Okay.
And the third is that my builder has recently quoted a High Court judgment, rather Supreme Court judgment, in which they have said that I need to pay VAT, that is at a rate of 100 rupees per square feet. So is the builder legally correct in asking me all this VAT as well as service tax? And the third part is, what is the legal course I can take against the builder?
Okay. Also, Gagan, have you written to the builder, spoken to them, tried to figure out why there is a delay in possession?
See, I have always visited, maybe every 6 months I visit my builder. I go to the site, but they've always quoted that there was some problem as far as the water availability in Gurgaon was concerned. Maybe there was some problem of funding. They've quoted these things, not officially through a mail, but yes, they have quoted these on the site itself.
Okay. So, project delay over here, he was promised possession in 2011-12.
Correct. So, recourse is available to you, Gagan, would be diverse. So, first is if you want to continue to go ahead with the flat and you don't really want to terminate the contract, you will essentially require to claim damages from him for the delay that has been caused and all the hardships that you are undergoing. So, for that, of course, you can quantify that and issue by way of a notice and simultaneously go before the consumer forum or the district forum for the purpose of claiming your damages. But in the alternative, if you don't want to go ahead and you want to terminate the contract, then of course you can claim refund with interest. Now, interest could be provided for in your agreement, so you will need to examine your agreement and understand what interest has been provided for. So far as your second question is concerned, I guess you're talking about the service tax and other taxes that are being charged to you because of the judgment that's later has been implemented. First, you also need to examine your contract as to whether the service tax was chargeable to you or not. There were instances where several cases the clause was totally silent. There were no discussions on this particular issue. At such time, the tax cannot be passed on to the flat purchaser. So you need to examine whether there were any particular clauses whereby it was stated that any taxes which were levied on the consideration would be passed on to you. If not, then it would be required for the developer to pay.
Okay, so essentially he has to get that checked.
Yeah, so he needs to examine his agreement and there was an explicit clause to that effect or not.
Okay, and you said he can claim damages, he can stay invested in the project and claim damages, or he can exit and he can
claim
ask
the whole
for
refund, yes.
Ask for refund with interest for the delay.
Yes.
Right. Is there anything else that he can ask for? Because is there anything else that he can, any other legal recourse apart from going to the consumer forum? Is there anything else that he should be doing?
The other forum would be the district court, again for the same reliefs itself. Now, so far as performance is concerned, I understand the whole project is delayed. So, of course, you can take directions from the court that it will be completed. It has to be completed within a stipulated period, and maybe he can be compelled to give an undertaking that it would be completed within a stipulated period, which is an extended stipulated period. So, of course, that is possible. But beyond that, as far as recourse personal to him is concerned, either he can claim damages or in the alternative, he could claim refund of the whole amount with interest.
Right, and Gagan, there's another thing that you can probably look at doing, that is check if the other buyers in that particular project have also gone and filed cases against the developer, in which case you all can actually approach the court as a group, and that will actually help your case much more. It will strengthen your case far more. Right, moving on, we have Zaki now, who's called in from Mumbai. Zaki, how can we help you? What's your question?
Yeah, my query is that we had purchased a property in Baikala, Mumbai, 20 years back in 97 under the Pagadi scheme, wherein you put some money and then you pay monthly rent to the landlord. Now, after almost 20 years, we would like to sell this property. So what I'm told is when you sell this property, you have to part away with the 33% of the amount to the landlord. So my question is it something legal that is 33%, or is it something that landlord can demand any amount, right from 5% to 80, 70%? So what are my rights to selling this property?
Right. Now, Pagadi is something that is very typical to Mumbai and also to certain parts of Delhi where you have old buildings. How does this work? How does this work, especially when you're selling the property that you bought?
So basically, these are tenancies which are governed under the Rent Control Act. So prior to 1999, tenancies could be created by way of rent receipts only. There was no clear requirement of a contract to that extent. So in your case, as you said, it's a Pagadi system. It's nothing but a tenancy. So tenancy, there is no as such a law as to what would be the amount chargeable by the landlord for the purpose of NOC. It only prescribes that you need to take prior consent of the landlord before transferring your tenancy. Therefore, it could be 33%, it could be less, or it could be more. Probably it may have been a market practice to charge 33%. Therefore, that's the quantum that has been told to you. But of course, as I said, for the sake of repetition, there is no as such a thumb rule or a law which is laid down which says what is the chargeable transfer charges payable to the landlord.
So what you're also saying is he may not actually be required by law to give these transfer charges to the landlord. He just needs to inform the landlord that so-and-so sale is happening.
Yes, prior consent of the landlord is required. But usually for the consent, he may be charged.
He will ask him for money.
Yeah. But as such, as I said, in law, there is no provision for any transfer charges to be paid.
Would it help if, he checks what was the last, in the last transaction that happened in that particular building, what was the transfer charge that was paid and, use that as a
precedent.
Yeah.
It may be recorded in the contract, it may not be recorded in the contract. So it may be difficult for him to get a precedent as a market practice which I am aware of. So the contracts usually have simple NOC stated without any reference to consideration. So you may have to, of course, it's a good suggestion that we could evaluate, but it may happen that there may be no reference of any amounts being received by the landlord therein.
Right. So ask around, Zaki. You might just be able to find out, in the last recorded transaction in that particular building, what was the transfer charge that was paid by the tenant in question who actually sold that property, and that you could use that as a guide when you actually go and speak to your landlord, and you will have to negotiate, obviously, because there is no prescribed percentage that you need to pay the landlord for transferring your tenancy. Right. Moving on, we have an email query now. Abhishek Kumar has written in, says he booked a flat in Lodha Casa Rio at Palava City, Dombivli. Now, he received the possession letter a few days back. He'll get possession in a month. He has learned that the OC, however, is not ready. Now, the developer tells him it will take 6 to 8 months to get the OC. They have requested him to take possession. He wants to know if he should take possession without OC. He also asks, does it take 6 to 8 months for a developer to get the OC? I can tell you this, you should not be taking possession without OC, right, Anshuman?
Absolutely, no doubt about it. Because he will be an illegal occupant and contrary to the provisions of law. So ideally, he should not be taking possession where the OC is not been obtained. In fact, he should reply to the letter wherein he is being sought to take possession, where asking the developer whether the OC has been obtained or not, rather than going by a hearsay information that he has received so far. And based on that, he can take the next step. Because it may be the case that if they have officially issued a possession letter, maybe the OC is there and he doesn't seem to be quite sure whether the OC has been obtained or not. The second question is whether it takes 6 to 8 months, depending on the kind of work that is pending. it will determine the period for obtaining OC. So if there are a lot of construction work pending, then probably the OC may take longer as well.
You know, Anshuman, a lot of developers nowadays have started a practice which is generally followed in commercial property, that of fit-out possession,
Correct.
which they are offering in residential as well. Now, should buyers ideally be opting for fit-out possession? Because I've also heard said that there is nothing called a fit-out possession in residential property.
Correct. In fact, builders who are more particular will never offer properties even for fit out, because that can create a situation for them at the time of OC. But nevertheless, when renovation and interior work does take 6-8 months, so while the finishing work of the building is going on, they permit buyers to initiate certain renovation work in the property so that he can immediately move in when the OC is obtained. It's much like a facilitation, but it's on a case-to-case basis. There wouldn't really be a thumb rule again for that. But as you rightly stated, in law, there is nothing like a fit-out possession, and there is nothing to really substantiate from books of law.
And essentially what you need to understand is once your building gets an OC, it means it is safe. It is habitable, it is safe. It is safe for you to move in and live over there, to occupy that particular property. It has got NOCs from the fire department. The local body in question has come and checked the safety of that particular building. That is when the OC is actually given to that building, which means it is fit for occupation. And that is why the OC is so essential. So key takeaway here coming for you right at the top of the show: do not accept possession of your home if the OC has not been granted for that particular building. It is illegal to take possession of the flat without getting the OC. Also, there is nothing like a fit-out possession as far as residential property is concerned. However, some developers have started, offering that nowadays. But you are well within your rights to say no to fit-out possessions as well. Only take possession of the flat once you get the OC in your hand. Moving on, we have a question that's come in on our website, www.mbnow.in. Madhumita Barua writes in. Now, she wants to know, how should a buyer go about doing due diligence checks before buying a home? She also wants to know what is the legal recourse a buyer can take if promised amenities are not provided. That's home buying 101, Anshuman. I can see you smiling. Give us a lowdown.
Yeah, so basically how to go about with the due diligence. So of course, there are 2-3 factors to any project. One is the title, of course. Second would be your permissions and approval. And the third would be execution and implementation of construction work. So far as first two are concerned, they are in prior in time. So your title has to be in place. For that, whatever the title deed, ordinarily there's a title certificate issued by a reputed advocate or a solicitor. So that can very well be perused by you. If it gives you a prima facie satisfaction, sufficient. Otherwise, you can insist for further documents to be provided to you to make yourself satisfied. And of course, so examining title deeds are important. Simultaneously, you need to examine the permissions that have been issued so far as that particular project is concerned. So depending on the nature of project, there could be some initial construction permissions. Prior to that, some approvals from competent authorities. If the project is big, then there would be permissions of MOEF, and which generally take a longer period of time. So those principal permissions are something which you can examine just to be satisfied that this project will be now taking flight so far as the construction activity is concerned.
Right, and Anshuman, also, if you could just break down the entire, the CC, the commencement certificate, and the permission that is given. You get partial CC, you don't get complete CC,
yeah, so
right?
basically, so far as Bombay is concerned, though you have an initial permission as you call IOD, which is an initial permission to do certain activities. Thereafter, you get CC. Now, commencement certificate is broken into several parts. So first is your plinth CC, where initial plinth of the building is completed and has to be completed. Upon that examination, further CCs are granted depending on the total number of floors. So as if there are podiums to the building, then the podium CCs are granted. So it's generally a phased wise CC that is usually granted now, though a full CC right now is not really happened. And finally, then there's an OC to the building. So of course, so that is the breakup of this whole CC. So far as IOD is concerned, that is a permission that is prior in time. So that ensures that basic permissions are obtained and the buildings, if there are old buildings, are demolished, or basic other requirements of the project prior to commencement of the work is obtained by the developer.
Right, so essentially checking the CC is very essential, because if you're buying a flat in a high-rise building, you need to check whether or not the floor on which you're buying the flat, whether it has got the CC, whether it has got approval for construction. Only then is that flat or that floor going to be legal. That is something that you need to keep in mind.
Correct.
Also, Madhumita, what Anshuman just gave us were the legal ways in which you can do your due diligence. Certain other things you can do. Try and visit the project construction site, at least 2 or 3 times before booking into that project, and ensure that you are visiting the site at 2 or 3 different times of the day, which means go there once in the morning, once in the afternoon, once in the night. You will know whether or not, you'll be able to check for construction activity on the site. Another good thing that you can do is also check with buyers. Say it's a phase-wise project, then you can probably check with buyers in phase 1 of the project as to the construction, as far as the delivery track record of the developer is concerned, the quality of construction, etc. All of that should actually go into guiding you to decide whether or not to buy into that particular project. Colonel Dylan has joined us on the phone line from Pune. Colonel, how can we help you?
Yes, ma'am. My question is like the builders, all the builders, they generally go for a payment plan, and most of the payment plans are, they do about 40 to 50% of work. That means they construct a slab level, plain slabs and things like that, and they collect money up to 80 to 90% from the buyers. What I mean is that 40% construction work is done, and the collection of money from the buyer is about 80 to 90%.
Yes.
And what happens when the builder, after he finishes 40%, then he has that, he can stop the work and put this money somewhere else. I know the rule has come now that money cannot be put somewhere else, but how do you curb this practice of having this unjustified payment plan from the builder? This is my question.
Very interesting question over there, and I must say that's a very proactive home buyer also. Someone actually keeping track of the payments as well as the construction activity in the project. Now, this is something that is quite common.
Correct.
What does a home buyer do in this case?
See, usually the agreement has to be drafted in a manner whereby the extent of work that is completed is directly linked to the amount of money that is charged to you. So it should not be a case where you have explained that 40% work is completed and 80% of the money is being charged. So the intent of the act, which is presently MOFA as well, is that the money should be pro rata to the extent of work that is completed. Therefore, if some of the developers are trying to modify the terms, you should ideally not agree to those terms, nor you should sign on such agreements, is what my suggestion to you is. Having signed such contracts, of course, there are practices in the market where they are intending to charge more and people have succumbed to such demands. But ideally, you should not encourage yourself to buy flats in such projects to avoid certain situations, as you rightly pointed off, of diversion of money and thereby the project getting held up in the long run.
Right, Colonel Dylan. So the simple answer is, if you're not comfortable signing that agreement, if there is something about the contract that you're not happy with, please walk away. Do not sign that particular contract. Also, Anshuman, before we move on, now this is if you're paying for the house out of your own savings, it's a different question altogether. But 90% of the buyers buy homes via home loans today. And home loans also, typically you sign a construction-linked agreement.
Correct.
Then it is a bank that is actually disbursing the amount. So what happens over there? Do you see banks actually, laying down the law and saying that?
Many a times the projects are approved by the bank. So in that sense, the payment schedules are linked to proper construction progress, and therefore such eventualities don't arise. Nevertheless, the home loan is an independent issue, and construction and development of project is an independent issue. So just because the bank has agreed to certain payment installments which were referred to in your agreement doesn't really mean that those are binding or they would be correct. So nevertheless, I would say that would not be a correct barometer to say that those are actually the correct payment schedules because the bank has agreed to pay by them. It is your independent lookout. You have to ensure that it has been independently investigated by you and you are satisfied with the payment obligation. Bank will keep disbursing, it doesn't matter to them because they are ultimately going to charge it to you.
Right. So what you're saying is you can't depend on the bank as well. You have to do your own due diligence, and the best thing to do is ensure that it is enshrined in your contract right from the beginning that the payment will only be done as per the construction.
Correct. So generally there are percentages that are referred to as to so much amount of percentage of your building having been completed, so much monies will be charged to you. So that is the correct way of charging in consideration to the purchasers.
Right. So it boils down to being very, very careful when you're signing that contract. MK Agarwal has called in now. How can we help you? Mr. Agarwal?
Yeah, good evening मैडम.
Good evening. How can we help you?
या मैडम जैसे बिल्डर एग्रीमेंट करता है तो अगर कस्टमर से एग्रीमेंट जो करता है अगर कस्टमर लेट होता है तो ही विल चार्ज 18% इंटरेस्ट. ओके.
हाँ जी.
अगर कस्टमर अगर लेट होता है पेमेंट में तो 18% पेमेंट इंटरेस्ट चार्ज करेगा वो. राइट.
Correct.
Right.
अच्छा, अगर बिल्डर लेट होता है उसमें फ्लैट देने में तो 1 साल 2 साल लेट होने से भी कुछ लायबल नहीं है वो. ऐसा एग्रीमेंट करता है वो.
अच्छा.
ऐसा एग्रीमेंट करता है इन द सेंस ऐसा एग्रीमेंट में लिखा हुआ है?
हाँ, लिखा हुआ है.
अच्छा, देखिए जो 18% ब्याज का इशू है, सो दैट इज कॉन्ट्रेक्चुअल. जो नक्की करेंगे, जो आप उनके साथ अग्री करेंगे वो हिसाब से वो 18% लिखा जाता है. कायदे में कुछ नहीं है. पर अगर बिल्डर डिले करता है तो उसके प्रोविजंस हैं कि उसको आपको डिलेड इस पे इंटरेस्ट भरना पड़ेगा और उसको आप चार्ज भी कर सकते हैं. अगर वो कुछ नहीं लिखेगा, ऐसे लिखा है उसने कॉन्ट्रैक्ट में, तो आप अगर कोर्ट में जाएंगे तो वो डेफिनेटली आप चैलेंज कर पाएंगे बिकॉज इट इज़ इन कॉन्ट्रावेंशन टू द प्रोविजंस ऑफ लॉ. तो मेरे हिसाब से वो हिसाब से आपको तकलीफ नहीं आनी चाहिए. यू मे सक्सीड इन दैट पोजीशन ऑल्दो आपके वो एग्रीमेंट में वो लिखा गया है.
तो अग्रवाल जी बेशक एग्रीमेंट में नहीं लिखा गया हो कि वो कॉम्पेंसेट करेंगे आपको, लेकिन ये एग्रीमेंट में जो नहीं लिखा गया है वही कायदे के खिलाफ है, कानून के खिलाफ है. इसलिए अगर आपको कोर्ट जाने की ज़रूरत पड़े तो अंशुमन का कहना है कि कोर्ट जो है वो आपकी तरफदारी करेगी. कोर्ट यही कहेगी कि जो कॉन्ट्रैक्ट है कॉन्ट्रैक्ट ही गलत है अपने आप में. ठीक है.
कंज्यूमर कोर्ट आपको रिलीफ वो मामले में दे सकता है. कंज्यूमर वो एग्रीमेंट देखेगी और वो डिसाइड करेगी कि ये गलत है, आपको इंटरेस्ट या डैमेजेस मिलने ही चाहिए अगर प्रोजेक्ट डिले हुआ है तो.
अच्छा अच्छा, ठीक है. थैंक यू वेरी मच.
Thank you very much, Mr. Agarwal. With that, we are rapidly running out of time on the show, but let me remind you about what we learned today. A key takeaway that we came across today was that you should not accept possession in any residential property without the OC. OC is the occupancy certificate. It is illegal for you to take possession as a home buyer without the OC. There is nothing called a fit out possession for residential properties. You can actually go and tell no to the developer for taking fit out possession. Only accept possession once the OC is obtained. That is clearance, that is a certificate that the building is suitable for human habitation. You need that OC, otherwise you will be in the wrong if you would be taking possession of that flat without taking the OC. That's all the time we have on today's episode of Property Hotline. Anshuman Jagtap, thank you very much for coming in. If you have any questions related to real estate, and we keep telling you this, whether it's about buying, selling, investing in property, legal issues like those we answered today, taxes related to property or home finance, get in touch with us. IDs are flashing on your screen. We'll get the country's top experts to answer each and every single question. Thank you very much for tuning into Property Hotline. Keep watching Magicbricks Now.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.